We are on. Hey, Allie, how are you?
I'm good. How are you?
Good, good. Well, today we're going to talk about a recent appellate court decision, as you know, Estate of Eskra v. Grace. This is your neck of the woods. This is not a typical family law case, is it?
Nope.
However,
Not at all.
our paths always cross, it seems, and it has a mixture of family law and probate, which is going to make this case very interesting. So why don't we do this? Can you start off with maybe a brief summary of what the facts were of the case?
Mm-hmm. So Brandy and Scott got married. They both had children from former relationships. I think her 2 children were adults and his daughter was 9. Before they got married, they signed a prenuptial agreement, I believe the day before the wedding. They each had independent counsel.
Everything's good so far.
So it's good so far.
Even though they signed it a day before the wedding under the law that's enforceable, and they both had independent counsel. Okay.
Yes.
Go ahead.
But in the lead up to to drafting the prenup, Scott's attorney drafted it and included some language about what would happen if either of them died. So in a prenuptial agreement, you've got 2 things that you're looking at, right? One is if you get a divorce, and the other is if one of you dies.
Let me stop you right there. You and I are really kind of learning about that second part, that there's provisions in premarital agreements about when you die. Because I know that, I don't know if it was a couple of years ago, you and I talked about, premarital agreements kind of die if the person dies because it's not estate planning. But we're learning through appellate court decisions that premarital agreements can affect what goes on after somebody dies. And this is going to be a classic example of that, right?
This changes a lot
Yeah.
for us and the way we think about this. I personally don't like it. We can get into that when we get there, but
Okay.
I think this is going to be fraught with difficulty moving forward. So there were certain provisions in there about if one of them died. Brandy told her attorney and told Scott that she didn't think that this was about when one of them died. It was if they got divorced. She wanted to take those death provisions, thank you, out of the agreement. She told her attorney that. There was some miscommunication between her and her attorney. She went to the Scott's attorney's office with Scott to sign the agreement without, she hadn't finalized things, I guess, with her attorney, right? And signed the agreement with the death provisions in the agreement.
Okay. So some of the other facts that I think are important in this case is that she was very vocal about the fact that she did not want the death provisions put in this premarital agreement, so much so that she told her own attorney that. She communicated, apparently, I don't know if it was an ex parte or not, but her attorney communicated that to Scott's attorney. And we know that she testified later on that she heard Scott saying something to his own attorney that, that should be removed, that there should be no death benefit. So we could infer from that she and Scott have had the conversation as well.
That's true.
Right?
Yes, that's correct.
And going into the marriage, one day before the marriage, she assumes that it's been removed because she's communicated this to her attorney, she's communicated this to Scott, and she knows her attorney communicated that to the opposing attorney, right?
Correct.
Okay.
Yes. All of those things are true.
Okay.
So fast forward 3 years, Scott dies in an accident. He was 45 years old.
Very young.
Very young. He dies, and what the opinion says, he dies intestate, which means he died without a will. She, as the surviving spouse, went to court to open a probate and get appointed as his administrator, as she has the right to, as being the surviving spouse.
Nothing funny about that.
Nothing funny about that. Straightforward, right out of the probate code. And the mother of Scott's child, so his first wife, objected to the appointment of Brandy.
Okay, that strikes me as strange. Okay, now I'm going to ask you about this because this is certainly within your field. What in the world does an ex-wife have to do with your administering your estate? I mean, it seems to me that that'd be the last person you'd want in there doing that.
She objected acting as guardian of the daughter, of the 9-year-old, of Scott's
okay.
daughter.
Okay. Was that the only objection?
Yes.
Oh, okay.
Yes. And then Scott's parents actually petitioned the court to get appointed as administrators of the estate. So that is also, if the probate code says first a spouse, then children, then parents. So right, in this case, his child is a minor. She can't petition, so the parents stepped in.
On behalf of the minor? Or no?
No.
They just get the right to do that per the code.
Exactly.
Probably something you see occasionally, I'm going to guess,
Yes.
where you have competing people asking for that.
Mm-hmm.
Okay.
Mm-hmm. Yep, it happens. Siblings a lot of times, What the parents argue is that Brittany is not entitled to be the administrator or a beneficiary of the estate because of this prenuptial agreement. What Brandy says is, no, that prenuptial agreement that I signed didn't have the death provisions in it. Or did she know it at that time? Actually,
No.
that's not clear to me.
It's not clear in the decision,
Yeah, it's
I
not
don't
clear in
think.
the decision.
So you're saying that she was saying that there's no death provisions, and what's the argument there? She was trying to get the parents not to be able to petition?
Correct.
Based on that argument?
Yes,
Okay.
she wanted to petition as the surviving spouse.
Okay.
And what the parents said was, no, there's this prenuptial agreement.
Oh, okay.
And Brandy said, no, I didn't, that's not what I meant to sign. What the prenuptial agreement that we signed was only in the event of divorce.
Okay.
So
So
it's not
then
applicable.
she, at some point she reads it, and then there's a dispute still between her and her deceased husband's parents over who gets to administer the estate.
Correct.
Interesting. Okay.
And it's important here, too, because no one disputes that the prenuptial agreement applied to the property, to Scott's property, that what it said was all of his property was his separate property. There was no community interest being built.
Because this was a second marriage. He brought property into the marriage.
Correct.
She didn't have the right to argue that it was community. She was basically saying that per the premarital agreement, I get my rights from this.
Correct. And if a person dies intestate, separate property, the surviving spouse, even if it's separate property, the surviving spouse still has an interest in it. So in this case, in this scenario, Brandy would have gotten half and the daughter would have gotten half.
Okay, so if there wasn't a death provision, then she certainly has some rights. She's got the clear meaning of the premarital agreement about what she would get, and then just by the probate code, there's that. Okay.
Correct. So what Brandy is arguing is, that's not the agreement that I meant to sign. And then we get into sort of the contractual, which is more in your area than in mine, but basically she's saying it was a mistake. I didn't read it. I told my lawyer, my husband, and he told his lawyer I didn't want that in there. And I went to my husband's attorney's office and I signed it without reading it. And
Okay. So continue. What happens?
And the court says, yeah, it's not our problem that you didn't read what you signed. you gotta read what you sign.
When I read this, I thought it was controversial as well, somewhat, only because of the fact that she signs it on the day before the wedding, and the opinion doesn't state that. What's her first name again? Brandy? Brandy contested it by saying, I was under duress or anything like that, because a lot of times if there's a wedding coming up and you send it the day before, that's the last thing you're thinking about. If it's presented to her, I don't know if it was presented to her on the day before, but didn't come up. What she said is, I didn't read it before I signed it. And she was arguing that there was a mistake, in fact, and based upon the code, the Civil Code of Procedure, the court should find that this thing is not enforceable because there was a mistake and there's provisions in the law for that. And so what we had then was an initial decision from the court saying, look, you're not going to bring in extraneous evidence, right? You can't talk about the things that the two of you were talking about before. We're going to just look at the document itself and your testimony that you didn't read it. Well, that was brought up to the Court of Appeal. The Court of Appeal remanded it. And this is what's interesting for a lot of practitioners out there. Extraneous evidence does come in for contracts like this here, which really opens up a lot of litigation because witnesses could come in and things of that nature. So she won on the first round, right?
Right.
It gets back into the trial court, and now she has the opportunity of bringing in her former attorney that helped draft the agreement. She could bring in, Uncle Joe, who might have heard the conversation. She could bring in letters that the two of them are writing and all this stuff. So she's got a fair shot at this, right? And then what happens?
Well, then she lost it at the trial court level.
Yeah, the trial court said, well, thanks, Court of Appeal, but I'm still going to rule the same way, which is interesting. When they remanded, I always think that the trial court knows how to fix the problem, right? It's like, you're telling me that. I get to try the facts. The Court of Appeal is never going to question me about that. But really what it's centered on at the trial level is whether or not her husband, Scott, also made a mistake, right? Because what she was saying is that Scott didn't read it either. And we both made a mistake. So the Court of Appeal said that when there's a unilateral mistake, then it's not grounds for non-enforcement of the agreement. But when both parties are mistaken, a mutual mistake of the facts, that would be grounds. So it all centered on, did Scott make a mistake? Yeah. And what do we know about that?
Well, and then welcome to my world, right? You're trying to get the state of mind of a person who's dead. And so they both brought in various family members. Her son testified that he heard them talking about, that this didn't apply at death. Then, of course, his stepdad, I think, said no. He was in an accident, and he told me he definitely was glad he did that prenuptial agreement because he wanted his daughter to get everything. So, I mean, it's sort of all lined up, right?
And don't forget, his attorney came in.
Oh, and his attorney.
His attorney came in and said that when he conversed with him, he was like, no, I want that provision in there. And he said, just ignore what she's saying. I want it in there. I think that attorney, Scott's attorney, probably held the most weight for the trial court. Right? The Court of Appeal seems to have concentrated mostly on that testimony. Now, what was really interesting here is that Scott said something like, yeah, you don't have to talk to her about that. Just leave it out. So was there some kind of fraud? Was he misleading? It wasn't like, no, we're going to keep it in. So, dear counsel, in spite of what your client wants, we're including this in this here. So here you have it. You'll find it within the agreement. There was none of that.
None of that.
And that's the part that you're angry about.
It's not the part I am partially angry about that because there definitely was. There were these four people, right? The two attorneys and the couple, and there was not good communication, or it seemed like very unprofessional, at least, right? So. Well,
let's not let the wife off the hook so much, because remember what did her attorney say?
Yeah, I tried to call her and email her, and I told her I'd be in my office all day, and I just never heard from her.
But she doesn't show up.
Yeah. That's true.
Now she was probably planning for the wedding.
Yeah.
I mean, she had other things to think about, and the premarital agreement was one little checkoff besides the flowers and the invitation list and all this other stuff. But she didn't come around and sit down with her attorney and go over the agreement before signing it.
I mean, she didn't even call the attorney to say, I'm going to meet with Scott and his attorney today. Is it okay if I sign this?
I didn't catch that part of it. Okay.
No, I mean, she didn't. Yeah. She didn't do anything.
Yeah.
So definitely. And I guess that speaks to also, right, when you're signing the prenuptial agreement, they're thinking about the wedding. What you're not thinking about is your new husband's going to be dead in 3 years.
Yeah.
I mean, that's pretty profound, right?
And that's going to lead to some lessons we could talk about for people that are entering into premarital agreements. There's quite a few in this case. I wanted to just dwell a little bit about the credibility factor, because the Court of Appeal had to basically say, look, the trial court makes the decision with regard to credibility. The trial court decided that Scott's attorney was credible, that there was no hanky-panky going around. He wasn't misleading, which would have been a defense from her, right? If she prevailed on that issue, that they purposely withheld information, they tricked me into signing it, making me think that that the provision wasn't there anymore. The trial court said that didn't happen, and the Court of Appeal had no other way than to say, okay, that's your decision, trial court. So, who knows what really happened? I mean, it's it's unusual for attorneys to send contracts back and forth for premarital agreements without pointing out what the provisions are, or the ones that are changed. I mean, you just do that as a normal course because you want to make a record of the fact that this is what we're talking about, and stuff for many, many reasons. But this is one where, it would have made sense, I guess. Interesting. Okay, so she winds up losing in this case, right? What's the bottom result as to who gets what?
The daughter got it all. The
Okay.
daughter got the whole estate because. So can I tell why I'm upset?
Sure. Yeah,
So
please.
The reason I don't like this is because the court is treating the premarital agreement as a testamentary document, which it's not. I mean, it doesn't meet the requirements for a will or a trust. It's a contract.
Isn't that strange?
I mean, my first argument in this was, this is not a testamentary document. It's a contract. Those are not the same thing.
Yeah.
And I mean, it doesn't appear. I think if they would have made that argument, it would have appeared in the appellate decision.
Yeah.
But that's what I don't like about this moving forward as well, right? Don't rely on your premarital agreement to express your testamentary desires.
It could have, though.
Apparently.
Maybe. Actually, we don't know. We don't know if it would have gone full board if that argument could have been made in probate court, because we never got past whether or not it was enforceable. But the fact that they were entertaining it seems like it is. And this is the second appellate court decision that we've seen within, I think, a year where there's been reference to a premarital agreement after somebody dies during the marriage. So I think we're learning that probate courts listen to this evidence, right?
Yeah. I think you're right. I just think it's a bad idea. I think it's poor planning. I think that you're leaving the opening. Listen, if you want to engage in your premarital agreement to say that we're keeping, this is only my separate property, great. But then you need to do a will that says, and all of my separate property is going to my daughter. I just think that there's too much opportunity for mistake,
Yeah.
right? Confusion, not sure. It doesn't give the clients the ability to clearly lay out what they want.
When you do lots of wills. So when you do a will, I assume that there's safeguards in place that you do to make sure that it's a clear intent and what's being given and things of that nature. A premarital agreement could be written very sloppy, right? It could just have some language in it that could be deemed as like a will, is what this seems like.
Mm-hmm. Mm-hmm. Again, yes, and the probate code has certain things that, first of all, there are the formalities of a will.
Such as?
It needs to be, if it's typed, it needs to be signed by the testator and needs to be witnessed by two uninterested parties, right?
Which didn't happen here. You had two attorneys. The attorneys wouldn't be two uninterested parties.
Mm-mm. No.
Okay.
Well, actually, they could, but it wasn't two attorneys. It was just one attorney.
Oh, the wife's attorney never signed it.
No.
Oh, okay.
Mm-mm. And then, because she wasn't there that day.
Okay. Right.
But if you don't have those formalities, if you can prove that this is what the person intended for this to be a will, because of this, and this, and I've had to do that too,
Holographic wills.
Or a holographic will, or if it's completely in your own handwriting and it's clear that it's a will and it's signed by you, that's an acceptable will too. Not a great idea because it just oftentimes leads to confusion. But this is a contract. It's not a will. It's just surprising to me that courts are going to accept any sort of contract, premarital agreement, whatever, as a testamentary document.
Yeah. So, like I said, this seems to be a movement in the appellate courts where they're looking at this as testamentary instruments. So what are some of the lessons? I mean, maybe I could start off with some of the things I'm thinking as a family law attorney, and then you could say something as an estate planning attorney. As a family law attorney, I would say, number one, give yourself plenty of time before the wedding to get all of this signed, sealed, and delivered. People come into our office, and one of the first questions I ask when I know that they're here for a premarital agreement is when is the wedding date? Because if they're coming to me and we're really close, I can't take the case. I want to make sure that the documents drafted properly, and it's not always easy because people get to tailor make premarital agreements. They're not all the same. A lot of times they have particular desires, and we got to figure out how to make that legally work. That process could take several weeks to prepare when you think about it. The second thing is that we never know if there's going to be negotiations after it's given to the other side, right? And a lot of times there is. People come in and, yeah, we want a premarital agreement. Well, what do you think my second question is? Who really wants it here, right? And typically it's one or the other. It's
Who has the money?
Yeah, that's right. They don't come into it holding hands and go, yeah, we want. Most of the times that's not the case, okay? Somebody has gotten some inheritance that's substantial, and the parents are saying, look, I love, your fiance, but you got to get a premarital agreement. We've worked way too hard for this, and we don't want to see you fighting over it. Or somebody has really made something of themselves and earned a lot of money. It could be a second marriage or something like that. And, they come into it, and there's room for negotiating. I had one case where my client was a school teacher, a young lady, and she was marrying into a family that is well known in Southern California. They were multimillionaires, and the fiance was getting $50 million. That's what his net worth was. And she came in and said, you know what, I just want to sign it. I don't care. And I'm thinking, wait a minute, what? After 30 years, you want to just say, I don't want any rights or anything? So, of course, I negotiated on her behalf, right? And that's what we do as we're representing people that might not have the money, is we're going to give the devil's advocate view and say, look, you need to consider everything. The decision's yours at the end, but let's talk about what it's going to look like in the future. And when you go through that process and then you start picking up the phone or writing letters to the other side, there could be lots of back and forth. And then let's assume that you have kind of a meeting of the minds. Then it's the drafting of the revised premarital agreement, right? Because there could be revisions back and forth. So that process normally is going to take some time. So my advice from learning from this case is don't do things at the last minute. I mean, signing a premarital agreement the day before the wedding just smells like there was a problem. There's also a more recent change to the law that says that the premarital agreement in its final version has to be given to both parties, and they have to wait 7 days before they sign it, because they understand that people could sign things under duress or not really thinking about it. That didn't apply here because this premarital agreement was signed prior to the change of the law. But had the wife in this case had more time to actually look at it, and her attorney was able to get her to come to the office, we might have had a different result, a different type of an agreement. And then the other thing that I'm also thinking is read what you.
The headline in the Met News, I was looking it up. The headline in the Met News is court says wife needed to read premarital agreement or something.
Yeah. But you know what? Nobody likes to read legal documents, and that's why you have attorneys.
Yeah.
I would never just give the premarital agreement to my client and go, yeah, why don't you go to Starbucks down there, read it, come back, and we'll sign it. You sit down with them and you go over it provision by provision. But if we believe her attorney, the attorney says that she never took advantage of that.
Yeah.
And again, it was probably because she's rushed because of the wedding. So those are my basic things that I take away from this. What about you?
I just do not think you should rely on your premarital agreement as your estate planning. I just think they are two different things. I think you're in for trouble.
Well, what should have Scott done in this case?
He should have done a trust. He should have done what we do in our office oftentimes is the premarital agreement and then a separate property trust. And then he could have put his house into that separate property trust. The premarital agreement would have governed what happens while he and Brandy were married, right? Because she was paying, she may have been, part of it was she may have been paying expenses on the house, but she wasn't going to get any reimbursement.
Right.
And then he passes away, even if it was a will, he passes away and it just says everything goes to my daughter and I'm disinheriting my wife. And we have this. And that's what we do. We have a premarital agreement that we've signed on such and such a date, right? And that's why I'm disinheriting her.
Yeah, and there's a lot of other things that he could have done. Got a lot of ways he could have benefited from getting a will or a trust, but such as the what do you call it? Maria always talks to you about this. When somebody takes care of you while you're ill and makes
a
decisions.
conservatorship.
Conservatorship,
Yep.
or I mean, there's just so much that you could put into that. There's no way that a premarital agreement could have that.
Correct. And would have avoided this, right? So that's the other thing. I mean, the other thing that's really important is, and I said this before, but I'll say it again, when she was signing that agreement on whatever date, how could she have guessed that her husband would have been gone in 3 years, right? I mean, young people die. And so thinking about that, and no one wants to plan for that, but it happens. So plan, you got to plan for it, especially if you've got a young child that he really did want to provide for.
Yeah, and so now that I've looked at these cases and have had many occasions to speak to you about this, every premarital agreement that we do here, we always ask, do you have estate planning? And we would highly suggest that you get two of these things. You get the premarital agreement and you get estate planning. I just think that it's not proper representation unless you tell the client about the pitfalls and that they have the opportunity to do that. Yeah. Now, let's change the facts just a little bit. Let's assume that they got married without a premarital agreement, but after 2 years, they decided to do a postnuptial agreement. And we have the same set of facts. We may have had a different conclusion because postnuptial agreements are different because the people now have fiduciary duties towards each other, right? When you're in a premarital agreement before marriage, there's no fiduciary duty, but once you're in that marriage, you have to handle it with the utmost care. And maybe a court of appeal would say, you know what, you should have been more careful in your wording, Scott, and your attorney. You shouldn't be just submitting documents like that, And so I don't know.
That was striking to me, right? When the attorney is saying that, when he says, I don't want you to bother going back and forth, don't tell her. And I was like, oh man. I mean, that conversation happens the next day after they get married, and that's a no-no.
It's just that statement tells you kind of that he was hoping that you wouldn't read it.
Yeah.
So, okay, well, great discussion. Just love the input that we got from you. Very good.
All right, good. Yeah.
Okay. Well, we hope that you learned a lot about this. If you're interested in a premarital agreement, I would say listen to this podcast maybe twice because there was a lot of detail in it. But, the lessons that we learned were hopefully passed on to you. And we'll see you next time in Exhibit A.
Thanks, everyone.